You have 20 minutes.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I rise and now stand before you to contribute to the 10 regulations before this Honourable House, which are here for affirmative resolution. Speaker after speaker on the benches opposite have simply said that they wish to have a firm date for commitment for the proclamation of this law. Speaker after speaker have made allegations that the government has not acted with alacrity in pushing this law. Speaker after speaker have attempted to deal with allegations of impropriety in the society that we live in. And permit me, therefore, Mr. Deputy Speaker, to address the many contributions put forward, to put forward a few observations and need for caution in respect of matters that have arisen, and therefore to proceed as follows. I had the pleasure, Mr. Deputy Speaker, of serving on the Joint Select Committee for several years for the establishment of what is now the Public Procurement and Disposal of Property Act 2015. I heard members of opposite say that this was legislation pioneered by the leader of the opposition, Kamla Prasad Bisesa, member for Siparia, who is not even in the chamber today. But we are told that somehow the opposition was the champion of public procurement. I'd like to say that the record of the Joint Select Committee, several committees, one after the other, will demonstrate that the opposition refused to make a policy commitment on the versions of law tabled before us as legislative proposals. You see, the records will demonstrate that the member for Siparia led a government which brought 2 separate legislative proposals, and that at the Joint Select Committee stage, we came to a halt in relation to the progress of the law because the government then, under the member for Siparia, would not make a policy direction. Fortunately, there was a great deal of public pressure, and coming close to the eve of the 2015 general election, we saw Act number 1 of 2015 come into form. Now, Mr. Deputy Speaker, if you listen to the members opposite, once that law was passed, there was nothing to do. And the Minister of Finance made a very important statement here today that I wish to repeat in a slightly different way as to how novel the public procurement step is going to be. You see, the member for Diego Martin Northeast said to Trinidad and Tobago the facts that the public has been shielded from public law introduction of argument and interference in public procurement. The Minister of Finance went through the NH cases, etc., the Udicot case, 2 cases, and pointed out that you could not intervene in public procurement other than in certain circumstances, but that this new law is about to introduce something which is unknown to Trinidad and Tobago. That, Mr. Deputy Speaker, is not business as usual. And the steps required to be taken between 2015 to 2021, as we've just completed, involved not only the passage of the law, but the appointment of the persons, the installation of the office holders in the Office of Procurement Regulator, the board, and importantly, the development of the regulations and the review mechanisms and the electronic structures and also the guidelines and handbooks And if you are faithful to what the law actually says, Mr. Deputy Speaker, you'll understand it is not in the simplicity of what the members opposite say. I mean, we heard a well-educated member today repeatedly talk to us about ineligibility. In fact, saying it, unfortunately, in a very different way, talking about ineligible. I'd like to just remind honourable members opposite, whether your handwriting is legible is not the same thing as being eligible for something. But when you look to the law itself, Mr. Deputy Speaker, the law itself says that you have to establish and incorporate the office. There is to be a procurement board. The tenure is then put into effect. You then get into the procurement regulator himself, as Mr. Munilal Lalchan has properly been constituted. And Mr. Deputy Speaker, the office of the President will reflect that those things did not happen in 2015 and took life in the period 2015 to 2021, but that very importantly, the Office of Procurement Regulator had to develop the structures for these regulations. The Minister of Finance has put onto the record that it was in the period of 2021, July and August, and in those periods, that the regulations were in fact put out in form. And Mr. Deputy Speaker, not only have these regulations been amended, not only has there been significant consultation on the regulations, but Mr. Deputy Speaker, these regulations are about to radically transform the system of Trinidad and Tobago. And I want to be on Hansard as warning that it may not be the paradise of efficiency that we're looking for yet, because you have to work your way into what challenge proceedings are going to look like. One of the regulations before us treat with the challenge proceedings. And Mr. Deputy Speaker, what are challenge proceedings? Challenge proceedings are to be found in Part 5 of the legislation, Sections 49 straight through and including Section 52 is where you get to the end of challenge proceedings. Challenge proceedings, Mr. Deputy Speaker, are very important because not only was the Minister of Finance clear and correct in saying that it is an alternative dispute mechanism that the review board was put in for, but the challenge proceedings, Mr. Deputy Speaker, go through a very important timeline. So what is a challenge proceeding? Anybody that alleges that they have a problem with a regular procurement mechanism can quite simply approach to challenge the procurement. That starts off with day 1 under sections 49 and 50, subsections 1 and 2 of section 50 of the Act. It then goes to day 4 under section 53. So on day 1, promptly upon receipt of an application for review, the office shall notify the procuring entity of an application for review. Day 4, after that, within 3 days of receiving an application, the office shall publish a notice in at least 2 newspapers. You then go within 3 days of that, on receipt of an application for review, you can order suspension, you can order the suspension of performance of the procurement contract or operation, and for so long as it finds suspension necessary. You then get to day 8. Within 7 days after the last event, you shall notify the procuring entity and all qualified suppliers. So if you had 100 people qualified to supply, you have to now inform 100 people and contractors of the application and the substance. So you put out a procurement, 100 people reply, one of the 100 challenges, you have to inform all of the 100 people of the notice of challenge. You then get, after day 8, you have a period of 20 days after that, working days, and you have to make a decision in the office. Then you get, after that, after the decision is done in writing, you must, no more than 30 days after making the decision, provide written reasons. So we're now up to day 51 of challenge proceedings. After that, a request for a review of the decision must be made by the office And 21 days after, they must take certain steps. We're now to day 72. After day 72, you get to section 51I of the Act, where these regulations are being dealt with. The review board must conduct a review within 21 days after the request for review. You're now up to day 93. After day 93, they shall complete the review within 28 days. You're working your way up. That's after the request for review. You're now up to day 100. After you get to day 100, you can appeal against the decision to the High Court. So you're now at day 128. When you go to the High Court and you're challenging that, you enter into the High Court processes, case management, case directions. You get into the hearing, you get into evidence and arguments put before the court in terms of submissions. You're looking at 1 to 3 years. After 1 to 3 years, you are then getting into the Court of Appeal. And in years 3 to 6, depending upon the cause list, you're then going to the Privy Council. That's in years 6 to 9. So let me put on the record what the review process looks like. You have an application out for any one of the services of public procurement, and what is public procurement is defined in the parent law. Public procurement is specifically defined as treating with, Mr. Deputy Speaker, procurement or public procurement means the acquisition of goods, works, or services involving the use of public money. A public body is the office of the President, the Parliament, the Judiciary, a ministry or division, the THA or a division, all municipal corporations, regional health authorities, statutory bodies, state-controlled enterprises, service commission, body corporate or unincorporated. It includes state-controlled enterprises, a company incorporated under the laws owned or controlled by the state, a company incorporated under the laws of Trinidad and Tobago which is owned or controlled by a company referred to in paragraph a body corporate or unincorporated entity which is supported directly or indirectly by public money. That means that every recipient of money under the Green Fund falls into this. You get a grant from the government, you're into this. We are now talking about the whole of Trinidad and Tobago's support by the use of public money, and I am cautioning that you are looking at a potential 9-year cycle by the time you get to the Privy Council, not including injunctive or tangential proceedings. And therefore, when you listen to members opposite, make this sound as if this is a simple thing. Wave a wand. Mr. Deputy Speaker, I am cautioning that you have to get the guidelines right. You have to get the handbooks right. You have to get the regulations right. And the only way to do that is not only by the law, but the plant and machinery, the people and the processes. But Mr. Deputy Speaker, I don't expect members opposite to understand that. After all, Mr. Deputy Speaker, in 1999, we saw the passage of plea bargaining legislation. We saw barely 10 in number, exercised in 20 years. We saw, Mr. Deputy Speaker, the passage of a sex offenders registry in 1999 with nobody put onto the register, because what the opposition does is they just turn their back on the law and they are not talking about reform and operationalization. And a law that is as complicated as this one has to be operationalized. And so when the Minister of Public Administration, Senator West, came here today to speak to the operational preparedness of the government's agencies and state enterprises, etc., that is not a fact which can be ignored. The establishment by way of cabinet notes and approvals for public procurement divisions, for public procurement entities to be managed in accordance with the law, Mr. Deputy Speaker, but I am cautioning that this is no uncomplicated matter. But Mr. Deputy Speaker, we have not dealt with this law in a vacuum. You heard the Minister of Finance today read out a very important statement in relation to the Financial Intelligence Unit. Mr. Deputy Speaker, this law runs concurrent with non-profit organization law. It runs concurrent with beneficial ownership. It runs concurrent with civil asset forfeiture, explain your wealth legislation. It runs concurrent with amendments to the Companies Act so that you have to declare legal ownership in shares. It runs concurrent with the demonetization process. It runs concurrent with the law of evidence. It runs concurrent with the creation of the criminal division, the family division, the civil division. It runs concurrent with the birth of 129 new courtrooms of criminal proceedings rules.
With all due respect to my learned friend, 48-1. 48-1.
Yes, so again, member, so tie in immediately, please.
Challenge proceedings end up in the court. The operational structures are to be tied in. You cannot look at the challenge proceedings regulations before us and be ignorant of the parent law. Wide latitude having been given to the member for Sawa Barataria on these points. I regret that Pointe-a-Pierre was not in the chamber at that point to be paying attention while his colleague was talking about illegible and illegibility as opposed to ineligible and ineligibility, Mr. Deputy Speaker. But we are not babysitting in Palm East, Mr. Deputy Speaker. We are dealing with the law, Mr. Deputy Speaker. So, Mr. Deputy Speaker, when we look to the operational structures, how can the members opposite not be cognizant of the fact that the companion to public procurement is campaign finance reform? And it is on the Parliament record. I'm not going to go into that because the Joint Select Committee is considering that work. But I drafted that law at the Prime Minister's instruction. So while we are creating the atmosphere for public procurement to be dealt with, Mr. Deputy Speaker, we must understand that we have not put all our eggs in one basket. And the structures, be it demonetization, be it any one of the elements that we are treating with, these are the important aspects, because when the procurement regulator goes to conduct an investigation under the Act, and that investigation is done under Part 4 of the Act in sections 41 to 48, that ability to go and get information at any person's place or any public authority is underwritten by the reforms that we put in the Income Tax Act, in the Police Complaints Authority, in the TTPS, in all of the legislation where we allowed for the entry for evidence.
He's strained all over the place, Deputy. 48-1. He's strained all over.
Again, Honourable AG, I know you are trying to tie in the particular various laws that have been implemented already with this particular one. But again, don't stray too far, please.
Thank you, Mr. Deputy Speaker. I'm certainly not straying. I will refer my learned colleague, the member for Pointe-a-Pierre, to the regulations in front of us. It's clear he hasn't read them, Mr. Deputy Speaker, because the public procurement and disposal of public property procurement methods and procedures are exactly what I'm speaking about, Mr. Deputy Speaker. Oh, woe be to those that cannot read the paper that the Parliament has printed for them, Mr. Deputy Speaker. So, Mr. Deputy Speaker, as I have 2 minutes left in this position, I would just like to say, we could stand up all day. I heard the member, the Honourable Member Tanku, forgive me, for the seat, Tabakit, Orapuch East, West, Orapuch West, forgive me, talk about $5 billion. And where did that come from? I could start with Life Sport at 500 million. I could start with Beetham Wastewater at 1.2 billion. I could start with the damming vessels at 1.2 billion. I'm nearly up to 5 billion already. And by the way, there are criminal investigations into some of those matters. So, Mr. Deputy Speaker, I take no advice from the member for Orapuch West, who is apparently not familiar with the status of largesse, expenditure, waste, and mismanagement under the UNC. Fortunately for us, Mr. Deputy Speaker, The public procurement regulations are before us. A massive amount of work has gone into them. I note the Minister of Finance has yet to reflect upon the work that the Attorney General's office did in this particular matter, but it was no easy task to take a very large bunch of regulations and dissect them into 10 individual regulations. But, Mr. Deputy Speaker, we are getting to where we need to be in the ethos and structure of where we are, and I'm confident the Minister of Finance will put this to bed. Thank you, Mr. Deputy Speaker.